thank you to Nicole. I'm super proud that I can say that Brain Hero, for example, is one of our clients, and we really support startups, particularly in technical. It's really a coincidence, so I'm super. I was super surprised when I saw Nicole here. So thank you for this. Thank you. I will be really short on this because I know legal compliance tends to be something that is not the most interesting one, but still data scientists have to think about it because they are on the source of it. And just to give you a very brief impression of what you should think of when you are doing something with AI or implementing AI. So, starting here, we do have a lot of legal implications, as you can see. There are aspects of personal rights. Interesting copyright law is something that is currently discussed around GPT, large language models. We do have data protection law, of course. That is very critical, and we do have the aspect of trade secrets for the user who is using AI tools as an enterprise solution, for example, where he feeds or trains the model with some internal know-how that can be protected as a trade secret, and there are some issues, but the good point is that they are all manageable. Even large language models can be used in a compliant manner. And I will show you how. When you use these large language models, this is the problem when you already train a model to think about the data source. Of course, that's the most interesting one. Which data are you feeding in? We just talked in another panel that if you're using anonymized synthetic data, that's the perfect fit because you don't have the whole GDPR problem. But you have to get there. How do you get there? You need some data set that is in a company, even if you want it or not, personal, in some stage, and you have to anonymize it by using technical methods. I'm not expert in that, but still, this kind of change from personal data to a synthetic data is a processing activity, and already this processing activity should be based on a legal ground. What is the legal ground? Why are you allowed to do it? Because the GDPR says processing of personal data is usually not allowed, except in very specific cases. If you have to find the way out to say, it's legitimate because I have to do it because I have a contract with the client and I need to process its data. Or because I have some overriding interest in processing synthetic data. So these are the thoughts you have to have when you're doing something like that. Another thing is the copyright perspective. If you're using large language models, you will very often process somewhere and somehow something that is copyright protected. Think of ChatGPT using all the texts or other tools using images. So there is a potential of infringement, but I'm very proud that the regulator had, I don't know if it was intentionally or it just happened, but last year he implemented a very interesting clause that's a text and data mining exemption. It allows to process copyright protected work if you scrape it on public sources. So this would be allowed and to duplicate it. Except when the platform operator, the website owner prohibits it. So if he has something included in his terms of use that you're not allowed to do scraping, or you're not allowed to duplicate the content there, then it's critical. So you have to think about it. How do you detect this exemption in terms of use? You have to look into it. So you won't do it manually, you will do it probably automatically. So this is the first step to get to this text and data mining exemption to be able to use copyright protected work. Another interesting thing is the trade secrets that I mentioned before. When you're using enterprise solutions and you're dropping a lot of know-how and data into your tool, be aware not to drop anything that is protected under trade secrets law, because it's only protected if nobody knows about it. If you put it in there and it can be possibly trained and used as a result for other purposes, and other employees have access to it, then it's probably no trade secret anymore, because where's the secret when everyone knows about it? So be sure not to use any trade secrets. And yeah, we do have also some aspects of the personal rights, where you have the right of to respect the private and family life, and other special provisions, particularly in the employment relationship with police. But I wouldn't put that much focus on it. I rather put focus on copyright, data protection, trade secrets when you're using it, and then if you're compliant with the free blocks, then in most cases you're compliant with the last one. So what about the output? That's also an interesting one, particularly who's the creator of the texts that are that is the result of large language models or the images. Well, under Austrian law in Europe, just natural persons can be an author of a work. So even children who are painting something, that they are the author, like Urheber, for all German-speaking people, because I know that legal language is a little bit different. So the author of work can just be a natural person. So now my question, what do you think? Who is the author of something that is the result of an AI model? Who is the author? Any thoughts about that? Any guesses?
Everybody that contributed to the data to the model.
Oh, interesting. So you mean the software developer?
No, the data that is used was created by the people, and all these people are the authors together.
Okay. When there are 100 people that have put some input in there, they are all joint author. Interesting. I will write an essay about that. What about your thoughts?
I think the person who generated the image and then used it, for example, like in the news recently, there was this photographer who won the prize for his AI-generated photographs, so he's considered the owner.
Goes in this direction, to the case. If you give enough instructions, the instructions are that clearly and that detailed, and you're just using the tool as something that should help you, like the pencil when you write something. It isn't that it doesn't write alone. You need to give instructions to do the writing. So if it's used by that detailed instructions, the user of the tool who gives the instruction remains the author of the result. If the instructions aren't that detailed, then nobody's doing it, because who should that be? The software developer, the company who is selling the tool? No, so then you don't have an authorship. But what happens in practice with most of the cases? You're dropping something in and you get something out, and you think it doesn't make sense what the ChatGPT writes, so you adapt it. And when you adapt it, and you adapt it that much that it differentiates from the first text, and it seems that you have something that is has an intellectual value that can just be done by a human. After the adaptation, it becomes your work, but just the adapted work, not the result. So in most cases, the user of the tool, if he's smart, will be the author of the work. So he will be, in German, we call it Urheber. Yes.
How do you define enough instructions? You say the model can give enough instructions.
That's very hard. We don't know that yet because there is no case law on this. What's enough instruction? Because you give instructions, but you still don't know what the result will be. So you always have kind of a black box that you're not able to understand.
Who's measuring the process? Like, who's measuring that I have given 30,000 instructions, I have given 2 instructions?
It should be evaluated on a case-by-case basis. For example, somebody who writes texts, plots, let's say they write a plot and they give a lot of instructions. There must be 5 actors and they have this role, and then this storyline happens. For example, if they would give such instruction for writing a plot, that would be enough to declare the result being a work of the one who used the tool, because it's so detailed. So that would be the easiest case, but as life shows, usually it isn't easy. So I'm sure that there will be a lot of open questions to clarify by the courts. I'm a little bit afraid of it because not every judge is that open-minded for new technology and understands how that works, but that's another thing. Looking at the time, let's talk about the output from another perspective. Well, we have copyright protection. It could be something that is patentable, the result, if you use it in a technical manner to help in researches. And again, if you just give enough instructions so that you can be declared as the one who invented the patent, that might be a possibility. Speaking of the output, what was the most critical point that Italy has raised in the last weeks regarding ChatGPT, the data protection authority there bans for a specific time the use of ChatGPT because by the results they found out that obviously they use personal data. So when the output is a personal data, you know that something doesn't go well because it shouldn't be fed by personal data in most cases. So for this kind of there can be a double check by checking the results whether the model works the way you want it to work. Yeah, what is AI itself? Can it be somehow protected? Yes, AI algorithms can be protected if they are hard-coded, if they are integrated in a component, if they are integrated in a code, then they can be protected under copyright law, they can be protected as know-how, they can even be an invention that is patentable. So this is super asset for every startup, every company that develops models. That's a huge IP and it has great value for investors and everyone else. Another interesting topic that I might just very briefly touch is the liability. Yeah, I know there are a lot of questions, who shall be liable if AI fails? Well, that's right now very easy to find out because the one who uses the tool uses a tool that should help to do something. So instead of doing it on his own, he uses a tool, and in most cases, the user remain liable for any failure that is done by the tool. So the software developer that was the first one who invented it. And then you have a lot of other stages with the company, the reseller, and so on. And other users in this, looking at these actors and these roles, they might also be held liable because if you buy a tool, then you want to have a compliant tool to don't have any failures, don't have any errors, don't have any liability cases. So if you must be, or if you are held liable as a company by using an AI tool, maybe you in most cases have to double check whether the contracts with all your suppliers in this supplier chain do consider this risk, and you have a possibility to hold them again liable for this damage that happened to you. So this is something that is very important to double check. Apart from this contractual liability, we do have a kind of strict liability. For example, in the mobility sector, or when deploying products and using product, in German called Produkthaftung. This is something that's a strict liability. They don't look at whether you have acted negligently, if you have done something by intent, or something else. They just look at, is the product safe, and has the risk occurred that shouldn't happen, and is there any damage? In these cases, you can be liable as a user under strict product liability laws. For example, when you are using a car, even as a private person, you can be held liable for that. That's more interesting for companies again, regulatory liability, like administrative fines that can be imposed by the GDPR and that are ranging into 20 million euros, sorry for that. This range is rather broad, and in Europe they are currently finding out companies, or the fines range between 500,000, 1 million for missing technical and organizational measures. So they are rather high if you're a small company and you get a fine of 500,000 euros. I don't think that many startups can live with that. So that's a real issue. And speaking of that, that's also why it's important to put focus on this compliance from the very beginning, when developing a tool, when implementing it, when finding a use case in a company or in a public authority. I don't know where, in all these cases, it's always good to know first risk, to know how much budget you want to put into compliance to cover the risks. Yeah, and as this isn't enough, the European regulator has something in mind to still amend the regulatory landscape by implementing a new AI Act and also new liability regimes, because they are well aware that it's very hard to enforce rights as a claimant if you are getting damaged. Let's say an employee is being discriminated and he doesn't get a job, and therefore he has a loss of income of, I don't know, 100,000 euros per year. In this case, he has real financial damage. But how can he prove that he has been discriminated by an AI, because he won't ever get to this algorithm, he cannot look into that. So that's the reason why the regulator has thought about that and said, okay, in some cases they should have access to specific proof, to specific documents, to be able to prove that their claim is legitimate. Exactly. Yeah, another upcoming regulation that is very well known is the AI Act, which follows a risk-based approach. Very briefly on that, there are 4 categories: unacceptable risk, high risk, limited risks, and minimal risks. And depending on in which category you will fall, they thought that, okay, you have to be compliant with more obligations if you fall into the high-risk sector, other than in the limited risk sector. Then you don't have to comply with that many regulations, which totally makes sense, because you have to look at the application in its specific context. Examples for high-risk applications, what can that be? Well, a lot in the public sector, in education, in mobility, in administration, when you're using AI to automate decisions for judges and so on. It's something that is very sensitive. One of the things that's also sensitive is rating and scoring tools that is commonly used by banks, insurances, and so on. So they're already thinking about how to design these rating tools in a compliant manner to be fit for the AI Act, because it takes a lot of time with all the obligations that apply or will apply in the future. And also, I don't know how many of you know the IMS algorithm in Austria. That's an algorithm that it was used 5 years ago and discriminated also people who had no job and said that they weren't able to find another job because they put them in a false, they categorized them falsely and said that they couldn't be able to do another job and will remain forever unemployed and so on and so forth. So this was a data protection issue because they used personal data to find out whether whether the person fits into another profession or not and can do something else. Such tools that are used by government in public interests, they are, for example, also high risk or will be qualified as high risk application. And there is an example of a list of what obligation will apply. It is a lot, and particularly the obligation that apply. It's very hard for a startup, for a company, to be 100% compliant because they don't tell you what you have to do. They just tell you to be well documented, to have adequate safeguards. What is adequate? Yeah, you don't give us any hints on that. You have to run a conformity check to label it by CE conformity, like you do it with products that you place in the market. So there are a lot of obligations that will come up, and nobody is challenging it. You have to do it first, and then the authority will come to, I think you did it okay, or there is something missing. So very similar to the GDPR approach, where they let companies do, and then they audit them and think, oh, no, I don't think that you do it correctly. But then, of course, all companies stand up and say, yeah, tell me what to do, I will do it. Just tell me how to implement something compliant. But still, the authorities are very, they're that open to that and eager to help. When it comes to guidance, at least in Austria, it's the way that they don't want to prejudice themselves by publish any rules. They rather say, let's do what you do, and then we'll see whether it's enough or not. So that's more or less the approach. And having said that, I'm already at the end. I hope that gave you a little bit of an overview of the legal implications, and I hope that it's digestible at this stage. Yeah, thank you.
Thank you. Any questions? Yeah, there is one question.
I have just a general question. So normally we talk about why algorithm is biased, right? We always know. But people are also biased. So is there is there anything going on in that direction already or not?
That's a very difficult question, because actually no law specifies what's biased and what not. So they leave it up to the people. So there's no obligation either set by the GDPR or other laws where they say we're not allowed to use data sets that are biased. So this will come up with the AI Act to have diverse and good data sets. So that implies that you have to have data sets which are not biased, but still someone has to decide whether it's biased or not. And if a judge decides that, he's also biased because he's just a human. So I'm not sure how they will solve the problem, but it is indeed a problem.
Second question.
Thanks for a great talk. First question is there anybody who is still able to, let's say, check what's going on with all the regulation in a specific case? And second, if there is nobody there, are you aware of how the legislator on national level will deal with that, especially, I mean, with this high insecurity you are producing with unspecific regulation or too much regulation, how it could be on a worldwide level?
Well, to your first question, there is just a bunch of people in Europe who have real expertise on that. I know that with all the ChatGPT hype, everyone says I'm super expert on AI because now they have, in the first time, used an AI tool. Well, I would say from my side that I have a real overview of the European landscape, but still there are a lot of experts. And the second question, that was an interesting one because how do you educate the society, the people? So there's a lot of gaps in the educational course. You will need a lot of new courses that are mandatory for students of all ages. You will have to think about new courses for professions like AI officer or AI compliance officers, or similar professions that will for sure come up in the next years, because someone has to understand what's going on, and there is a lot of need to have know-how from different fields. If you're a technician, then you're very good qualified to understand that and to gain know-how on the other fields, like the commercial one, the ethical one, the legal one, and then you have a good. That is what a good compliance officer is like. It's similar to cybersecurity, I would say.
Okay, so I have as well a small question.
Yeah.
Because I see there are no right now. So while you were talking, I was very roughly, because I'm a huge Asimov fan, I was thinking of this robotic goals, right? Robots don't harm human and all this, written 1970 plus years ago. But joke aside, what do you think is the case currently? Because many people are saying that the regulation aspects of EU kill innovation. So often, we have the GDPR Act, we have some other regulations also on the sustainability space. We are having this Green Deal kind of thing. I, for myself, as an expert, see, I will not answer it, but I see it as even a chance as well for us, while other nations and other domains of this world, let's call it like this, were not so democratic, or also not practicing our methods of human rights and everything, ensuring that harm is not being done in the society through technology only or spying people. It's seen differently, let's say in China, India, or somewhere else in the EU. So it is as well, it can be a huge chance as well for us. But what is your take on that? Are we really over-regulating ourselves and also killing the innovation on that end? Because it's maybe very crucial.
It is, and I will just have some thoughts on AI, because AI isn't right now that regulated. And I think that the next months and the next year will show whether the regulator is faster than innovation. Because when innovation is faster than the regulator and everyone uses it, the regulator tends to accept it. So it's a matter of time. You won't believe it, but Google Images was a huge issue because they reproduced and linked images of third parties, and that was very critical. But it was so often used, and the hype was so huge that the regulator wasn't able to stop this, and then he had to amend his position and to accept it. And so they defined rules that allow such machines, and that was 20 years ago, and then we should learn from history, so it's a matter of time.
Well, thank you so much for being here, sharing the insights. Yeah.